This conference will now be recorded.
Okay, we're streaming. Dr. Schottenstein, you're welcome to go ahead and start the board meeting.
All right, thanks everybody. The time is 10:04 a.m. The August 12th, 2020 meeting of the State Medical Board will come to order with the following members present via video conference. Dr. Rothermel.
Present.
Dr. Safran.
Present.
Mr. Jackalone.
Here.
Dr. Sohn.
Present.
Dr. Johnson.
Present.
Dr. Coccarello.
Present.
Ms. Montgomery.
Here.
Dr. Feibel.
Here.
Dr. Bechtel.
Present.
Myself, Dr. Schottenstein. A note on the order of agenda items. During today's meeting, we will need to make sure that we address the Federation of State Medical Boards agenda item right at 2:00 p.m. If there is unfinished business, we will need to move those agenda items to after the FSMB meeting. Do I hear a motion to approve the minutes of the July 8th, 2020 board meeting as drafted?
So moved.
Dr. Safran and Dr. Bechtel, thank you. All in favor, voice vote, aye.
Aye.
All opposed? Thank you. The board will now consider the report and recommendations appearing on today's agenda. Has each member of the board received, read, and considered the hearing record, the findings of fact, conclusions, and proposed orders, and any objections filed in the matters of William R. Danko, MD, Enrico L. Danzer, MD, Timothy John Morley, DO, and Arthur H. Smith, MD? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Jackalone? Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Further, does each member of the board understand that the board's disciplinary guidelines do not limit any sanction to be imposed and that the range of sanctions available in each matter runs from dismissal to permanent revocation or permanent denial? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Jackalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Does each member of the board understand that in each matter eligible for a fine, the board's fining guidelines allow for imposition of the range of civil penalties from no fine to the statutory maximum amount of $20,000? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Jackalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. In accordance with the provision in Ohio Revised Code 4731.22F2 specifying that no member of the board who supervises the investigation of a case shall participate in further adjudication of the case, the secretary and supervising member must abstain from further participation in the adjudication of any disciplinary matters. In the disciplinary matters before the board today, Dr. Rothermel served as secretary and Dr. Safran served as supervising member. During these proceedings, no oral motions may be made by either party. Finally, respondents and their attorneys addressing the board will be allotted 5 minutes to do so. The board parliamentarian will advise when the 5 minutes has expired. The assistant attorneys general will be subject to the same limitations. Please turn to the matter of William R. Danko, MD. Objections have been filed and were previously distributed to board members. Ms. Lee was the hearing examiner. A request to address the board has been filed on behalf of Dr. Danko. 5 minutes will be allowed for that address.
Thank you. Members of the board, my name is Beth Collis, and I'm here today with Dr. Danko. This is actually a very straightforward case, but the ways in which the court and the board address these kind of cases are cumbersome and often do not fit the facts in the case. This is actually a mental health case. Dr. Danko wrote 2 prescriptions for himself for Adderall and signed one of the prescriptions or both the prescriptions in the names of his nurse practitioner. One prescription was filled and the other prescription was rejected by the pharmacist. Dr. Danko has not denied his conduct. He prescribed the medications to treat himself in a time of extreme stress and anxiety in an effort to self-treat. This was a mistake. However, as we see in other mental health cases, when people are under extreme duress, they often make poor decisions. Dr. Danko should be punished for his error, but this mistake in an otherwise unblemished 28-year career should not result in unreasonable and unjust sanction as recommended by the hearing examiner. If you impose the sanction imposed by the hearing examiner, to start a suspension today, as opposed to in April when his license took effect, he will effectively serve a 300-day suspension for this conduct. The court recognized Dr. Danko's conduct resulted in some type of impairment, and he was approved for the intervention in lieu program, as the court doesn't really have another program to deal with mental health issues. The board has also not treated this case as a mental health case. The board has proposed to take action against Dr. Danko for a B9 violation, conduct that constitutes a felony, and a B28, substance use disorder. However, Dr. Danko does not suffer from alcohol impairment. He's been assessed 5 times and no treatment has been recommended. He submitted to a 72-hour evaluation at the Ridge, and Dr. Mark Whitsitt, who testified at our hearing, determined that no treatment was recommended and that he was fit to practice. He also sought an evaluation with psychiatrist Dr. Alvarez, who likewise determined that while he was suffering from an episode of a mental health impairment when he made the poor decision to prescribe to himself, that no treatment is recommended at this time. Dr. Danko never tried to avoid or evade the board's investigation. As he testified, letters were sent to him at his former home where he had not owned the home or lived for over 3 years. He did not receive any of those letters that were sent to him. Dr. Danko's license has been suspended since April. He has been assessed by the board-approved treatment provider and determined to be fit to practice. We ask that you impose a 90-day suspension that starts from when this board suspended his license in April, and that you impose a sanction of a $7,500 fine and not the sanction as imposed by this hearing examiner. I turn the rest of the time over to Dr. Danko.
Good morning. I'm Dr. William Danko. I'd like the board to know that I do take full responsibility for my conduct. 2017 and 2018 was a very stressful and difficult time for me. After a 20-year marriage with 4 children, I was in the midst of a very difficult divorce, which I did not want to happen. I also learned at the same time that I owed hundreds of thousands of dollars in back taxes for an urgent care that I own and operate in Cincinnati. In addition to this, my father was critically ill during this same time, and I was spending a great deal of time helping to deal with important decisions that had to be made by the family members for his care. I felt stressed and overwhelmed. I felt that I could not concentrate and believed that I was experiencing symptoms of adult ADD. I had briefly been prescribed medication in medical school for similar symptoms to help me focus. So I believed at the time that I could take Adderall to help with my concentration issue. I should have gone to my own doctor and sought help. I realize this now. But at the moment, I made the poor decision to prescribe to myself, and I signed my nurse practitioner's signature to the prescription. I was embarrassed to tell my colleagues and even my own doctor that I was struggling. I don't think I even admitted it to myself. I have completed every assessment required by the court and this board. I have submitted to 5 evaluations and no treatment had been recommended. I have been determined to be fit to resume work as a physician. I am in full compliance with the intervention in lieu program. My license has been suspended since April. I am struggling financially to support my family and to keep my urgent care up and running during this pandemic. I simply want to return to work. I request that you reinstate my license and reduce the monetary fine, as it will be impossible for me to pay the excessive fine recommended by the hearing examiner. I am already behind in alimony and child support. I have not avoided punishment or failed to take any responsibility for my conduct. My license has been suspended and I'm working hard to get back on my feet financially. I understand how stress can manifest itself. I understand that if I'm experiencing stress or anxiety, that I will seek help from my personal physician.
Sir, 5 minutes has expired.
Does the Assistant Attorney General wish to respond?
Yes, just very briefly. Good morning, board members. First, I would like to thank Ms. Collis and Dr. Danko and the hearing examiner for doing this hearing remotely. It went quite well. We had witnesses testify, and during this time of the pandemic, it was nice to get through the hearing quite well. So I'll keep my comments very brief. I think that the hearing examiner did a fabulous job of talking about the facts and testimony that came out in the hearing. Just a couple of things to point out that she found specific to this case. One of the things that she stated was that Dr. Danko appears to be a man who has managed to mostly avoid consequences and responsibilities for his felonious conduct, and that instead of seeking out help, he decided to commit 2 felonies that specifically dealt with prescribing. So I think that the board needs to discuss what they want to do in a situation where we are dealing with prescription writing fraudulently and issues related to mental health. And again, Dr. Danko did bring that up in the hearing. So I would ask that the board use your expertise. I am satisfied with the hearing examiner's report and recommendation, and I would ask you to adopt the sanction as proposed. Thank you.
Thank you. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Danko? Motion?
So moved, Dr. Cockrell.
Thank you, sir. Second?
Second, Giacalone.
Thank you so much. I will now entertain discussion concerning the matter of Dr. Danko. Is there any discussion? So I guess
I have a question.
Summary.
Oh, Dr. Schottenstein, go ahead. I would defer to you first.
No, really, my pleasure. Be my guest.
I'm troubled by Dr. Danko's felonious, the forgery. I'm also troubled by the fact that he's paid the consequence of 5 different evaluations. And I don't know what that cost is, but I assume it was fairly substantial. I think the fine is excessive. And frankly, I think that I would agree with the, rather than having the suspension start as of today's decision for 6 months or no less than 6 months, that we take into understanding that he has already been suspended, frankly, summarily by law in April 8th. And so as a result of that, he's already had substantial suspension of his license and would certainly find a 3 more month suspension to be more reasonable than starting 6 months as of today. And I would so move that we amend the proposal to cut the fine and perhaps in half, as proposed by the Dr. Danko's attorney, as well as to run the suspension for 90 days rather than 6 months starting from our decision today.
So to be clear, you would have the, you would essentially waive the suspension. In other words, looking at it as though it had been from April on and making it 90 days, that is essentially, we would forego the suspension.
I would propose a 90-day suspension as of today's decision and a
Okay.
cutting the fine in half.
Okay, so we have an amendment. Is there a second?
Can I ask a question of Betty before we second it? Is that to maybe amend it before, because I like the idea, but can we make it 180 days from April 8th when he was suspended?
I would not object to that. I just think that 6 months from today's date is too excessive. So if there were something that we could reach as a compromise, and again, I'm not at all diminishing the fact that he forged scripts, which is highly inappropriate. And this case appears to look as if the court was finding a way that he really didn't qualify for treatment in lieu, but there was no other vehicle, and so the court used whatever tools it had, which were insufficient. So he's already suffered some consequences financially. So I would agree with you, Dr. Feibel, if you wanted to run an amendment that granted the suspension from April. We worded it in a way somehow less than 6 months from today's date would be fine with me.
So 180 days from.
And if I heard right, cutting the fine in half, which would be $9,000?
Yeah.
Okay. Do we have a second?
Second.
Dr. Soren, thanks very much. Further discussion then, please, on the amendment. Mr. Giacalone.
Yeah, I would agree with it, but I think this case is a little unique. I don't think, obviously, he has an issue with substance abuse. He has an issue with veracity in terms of, trying to get his nurse practitioner to take the fall or take the excuse for him. Secondly, the question about why he didn't respond to all the notifications he received from the board. I just blew those off, or it appears that case. That's bothersome too. Again, I don't think we need to go overboard, but I think it should be clear that this isn't necessarily a saint here we're looking at who is wrong. I mean, it's one thing about mental health issue, but then there's an issue about lying, and I think further lying without receiving anything. So that's my 2 cents. I don't object to the amendment, but again, I don't think he is as much of the victim as he's being portrayed here.
Thank you so much, Mr. Giacalone. I guess I have a couple thoughts about this as well. I can appreciate why multiple assessments found the doctor does not have a substance use disorder because it appears he doesn't meet criteria for that condition. But at the same time, it's possible to abuse a substance without having a substance use disorder. And I think when you forge a prescription for a maximum recommended daily dose of a highly controlled substance to self-medicate mood or anxiety, sorry, you guys just, can you see me okay?
Right, we're
Sorry, I got a little bit of a glitch there. So sorry, what I was saying then is, when you, forge a prescription for a maximum daily dose of a highly controlled substance to self-medicate mood, anxiety, and attention span, then one is essentially abusing that drug. And this is how people develop substance use disorders. Who knows where this would have ended up in that regard if the doctor had not been caught early. So there was Adderall abuse, even if the doctor does not have a stimulant use disorder. From reading the evaluations, it does sound like the doctor endorsed a history of intermittent depression, anxiety, and attention span issues. And while stress is unpleasant for everyone, people prone to these issues have almost like an allergic reaction to stress. So it's important, I think, for the doctor to have a therapeutic relationship with a doctor and a counselor for those times of stress. And I think it's important that a psychiatrist make the determination as to how to address these issues medically when they occur. It's hard to focus when you're anxious. And so sometimes the way you get somebody's focusing better is by treating the underlying anxiety. There was a very real chance that the Adderall could have made things much worse because stimulants can exacerbate underlying anxiety. So the doctor prescribed himself a maximum dose of a highly controlled substance on 2 occasions. He did it deceptively by abusing the nurse practitioner's license. And then he asked her to lie for him. And I don't feel like the level of mental health concern is substantially mitigating in that regard. The fact that this occurred in the absence, too, of a drug dependency issue is almost worse because it implies a willingness to engage in that behavior in the absence of the influence of drug dependency. That's why this case is different from those of other physicians whom the board has disciplined for forging prescriptions because those physicians engaged in behavior under the influence of their impairment. So I'm agreeable to the amended order, but just sort of wanted to share those thoughts with you. Is there any further discussion?
Dr. Schottenstein, would you suggest that, given your comments, that perhaps we attach again, we'd have to, I think, have a waiver here, but attach some requirement for mental health counseling?
Well, I think in the proposed order, it does speak to that in the sense that he's going to have to be compliant with the court order. And there is a request during interim monitoring for the doctor to submit a CV of a psychiatrist who he will, be in treatment with.
Is there anything else, given your expertise, that should be added to the order in terms of mental health training?
I appreciate that. I don't think so. I think really what the doctor needs is to have ongoing relationships with his mental health treatment providers. He was diagnosed with an adjustment disorder, which basically means that in a period of stress, one can have a flare-up of mood and anxiety issues, and that when that stress resolves, those issues can subside. But, ideally, if one is prone to things like depression and anxiety, you want to be able to hit the ground running. If you should have a flare-up, it's not the ideal time to start looking around for somebody to find for treatment. I think the gentleman needs to have people on board that he's checking in with from time to time, essentially as maintenance. And so ideally with this order, I think he'll have that.
In response to Mr. Jackalone comments, it is troubling the whole delay because of failure to properly notify or get proper notification. But it's interesting. We finally decided to, I think, pick up the phone and call his office, or did something go to his office, as I recall. So it is something for us as a board to consider and process when we have failure to properly get notice that we consider a very simple thing of, like, we know where he works, and let's just go there. Let's pick up the phone there. So there is some, with response to Mr. Jacalone's comments, some of this is on us, I think. Certainly he had a responsibility to tell us he was moving in the course of all of his other things. I can understand how he would forget, but nevertheless, we knew where he was working, and we finally found him. So that's just a process question I think we can clean up fairly quickly, address in the future as Stephanie is looking through, Ms. Luke is looking through processes.
Thank you for your thoughtful comments. Are there any other comments or discussion? Okay, so maybe we'll have a roll call vote on the amendment, please. Dr. Rothamel?
Abstain.
Dr. Safran?
Abstain.
Mr. Jackalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Caccarella?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Abstain.
And myself, Michael Schottenstein, yes. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Danko? A motion?
So moved, Dr. Caccarella.
Thank you, sir. Second?
Second, Dr. Johnson.
Thank you so much. Before voting on the motion to approve and confirm as amended, is there any further discussion? Okay, roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Jackalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Caccarella?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Abstain.
Myself, Michael Schottenstein, yes. Thank you so much, everyone. Please turn to the matter of Enrico L. Danzer, MD. No objections were filed. Ms. Lee was the hearing examiner. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Danzer?
So moved, Dr. Caccarella.
Thank you, sir. Is there a second?
Second.
Thank you, Dr. Bechtel. I will now entertain discussion concerning the matter of Dr. Danzer. Is there discussion? Please, Ms. Montgomery.
Everybody's being quiet today. I'm sorry to be noisy about this. I am troubled, and I think I've commented to you about this. I'm troubled by the fact that this case, I make no mistake, cheating is not to be excused, particularly when our doctors, we don't want to go to the lowest common denominator. We want to go to the highest standards of care. My biggest concern is that we are going to seek a reprimand on behavior that is over a decade, is 7 years later. And so my only comment is, I think this certainly, if we had come to this maybe a year after it happened, or 2 years after it, we might be even looking at a more serious consequence. 7 years later, where he has apparently had an exemplary career, really troubles me. So I guess I would ask Dr. Schottenstein and those who are dealing with the federal the Federal Medical Board folks, why can't we find out about these things in a timely fashion so we can act in a timely fashion? Now we look like we're slapping this man so much later than necessary, and to be effective, it looks like we're taking, it's just bad. I think justice demands it be done as quickly as we know about it, and we knew about it many years ago. But we are now, not we, I meaning the medical profession knew. Ohio learned about it, and we're, by our rules, now reprimanding him. And I hope that you could at least, in this day and age, having a central database for discipline is it's not a remarkable or revolutionary idea. In fact, it's long overdue if we don't have it, so that we don't have to delay in an appropriate discipline. And I guess I'm just, I understand a reprimand is appropriate, but it seems so untimely. And I hope that Dr. Schottenstein, you and Ms. Luca can do something at the national level to get a database so we can act in a more timely fashion. It's just not fair to anybody. It's certainly allow us to be more efficient.
Thank you very much for your thoughtful comments. I think one of the things that we need to keep in mind is that he did not apply for a license in Ohio until October of 2019.
Right.
And so that's sort of when the ball gets rolling for us. And I don't really know that we have a lot of discretion in terms of being able to sort of backtrack in that regard. I appreciate your concerns, of course. I think it would have been one thing if he had, after engaging in the cheating behavior, reconsidered his actions on his own, gone to his administrator on his own and said, I did this behavior that I'm not proud of. But essentially it all came out because he got caught, right? And so what I would also say is that, cheating is absolutely unacceptable, and it is unfortunate that it follows the doctor years later, but it's appropriate. And it's part of the reason, besides the inherent unethical nature of the behavior, but it's part of the reason why you don't do that, because the integrity of our board exams is integral to being able to rely on the competence of our licensees, and it gives the public a sense of confidence in our system. Really, anything less than a reprimand could give the appearance that we don't really take the matter seriously, and I think that could have negative consequences. And so I think the order is entirely appropriate. Any further discussion? Mr. Giacalone.
I would agree with you, Dr. Schottenstein. I think, we see it more and more. I mean, look at the whole issue with the pharmacy fiasco and cheating, getting the answers in advance. I mean, we have to send a message that this is inappropriate. And when we just let this one go by, just because, California did something, I think it's inappropriate. Granted, give the man credit. He did a wonderful thing and took the right steps, etc. But you're right. It was after he got caught. Had he not got caught, I think the question is, would he have done anything? I'm not sure. But nonetheless, I think we send a bad message if we just kind of say, okay, well, this is fine. You did it, but we're going to let you in. I think reprimand's appropriate. And again, it doesn't seem like it's hurt him in the past, so I don't know why it would hurt him in the future either. But it does send a message to anybody else who's thinking about it. You don't get a free ride.
Thank you so much, Mr. Giacalone. Is there further discussion? Okay. Let's have a roll call vote then, please, to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Danzer. Dr. Rothermel?
Abstain.
Dr. Saffron?
Abstain.
Mr. Giacalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Thank you. Please turn to the matter of Timothy John Morley, D.O. Objections were filed and were previously distributed to board members. Mr. Porter was the hearing examiner. A request to address the board has been filed on behalf of Dr. Morley. 5 minutes will be allowed for that address. Well,
Dr. Morley, you're still muted. Dr. Morley, I'm sorry, can you hear me? This is the board parliamentarian. You're still have your microphone muted.
Okay, I'm sorry. Can you hear me?
There we go.
Okay,
Yes.
I apologize for that. First of all, I'd like to say that I'm sorry to the board for causing them to use this time and the state's resources to address this issue. I apologize for that. I would also like to say that I appreciate the treatment that I received by Ms. Pelfrey and Mr. Porter. I appreciate the fact that they did indeed state that I was completely cooperative with this investigation. I'd like to state that my medical license and my career is very, very important to me, and I deeply regret and take full responsibility for all of my actions that occurred in New York 3 years ago. And I'd like to reiterate my apology to you and to my profession for my actions. I would like to stress a few things, please. First of all, I'd like to stress that there were no allegations that I actually infected anyone with hepatitis C or any other infectious disease. My New York license was not suspended for any safety concerns to the public or anyone. The board addressed any safety concerns initially when I offered voluntarily to cease any phlebotomy or anything with the needle that would alleviate any safety concerns pending an investigation. That investigation took place. There was no one else that had any kind of infectious disease or hepatitis C. It was only the original few people who I had diagnosed over the course of the previous year. Instead, my New York medical license was suspended for my inability to comply with a 24-hour request, a request to turn over my medical records within 24 hours. That was an impossibility for me. I did have the records ready. I did not have the billing.
Dr. Morley froze for a second. If you'd like to.
Citing sanction violation. I'm sorry?
You were frozen for a second. So you might want to repeat your last few sentences.
The last things we got actually is when you.
Oh, okay, I'm sorry.
From when you said you had an inability to comply with a 24-hour request to cover medical records, we dismissed everything after that point.
Correct. My medical records were indeed ready. The notes were ready for review. The billing records were not, and that was explained why it was a physical impossibility to do so. That was explained in the pleadings. But I would like to state that, in deciding sanctions, please keep in mind that my license was suspended in New York for a technical rule violation, a rule violation that has no equivalent in the state of Ohio. There's no 24-hour rule in Ohio to turn over your records. I would also like to state that I've been practicing medicine now in Ohio for 18 months. My practice in Ohio is totally unlike my practice in New York. I basically diagnose physical injuries. I refer to proper referral base. I've reestablished my referral base that I had for 15 years with the Cleveland Clinic and with University Hospital, and that's going well. I've completed roughly 80 hours of continuing education on infectious disease, record keeping, and proper office management. And I would hope that this board would agree that I pose no safety threat to anyone in Ohio. I respectfully plead that you give me the opportunity to practice medicine, certainly with sanctions, but without a suspension. Just as I have a few seconds here, I guess this is my only practice, my only source of income. I have no partners. If this practice is suspended, it's terminated. I have no way of supporting my wife or my daughter or tuition or mortgage. But I just wanted to say that. Mr. McGovern?
Yes, Jim McGovern, I hope you'll agree that a suspension at this point is excessive and unnecessary given the record production issue that triggered the underlying New York suspension. A probation, practice restrictions, and a fine should suffice to address the violation and protect the public. The New York suspension, as he said, effectively ended his New York practice and created a financial hardship for Dr. Morley and his family. He's worked hard to get back on his feet here in Ohio, where he's practiced without issue for the past 18 months. A suspension of his Ohio license will effectively destroy his Ohio practice and resume the financial hardship he's working his way out of. Thank you.
Thank you so much. Does the Assistant Attorney General wish to respond?
Good morning again. Thank you. This hearing actually took place in person, which seems completely and absolutely foreign to me at this point. This is a case that has been around for a while. I know that Dr. Morley had prior counsel and later retained Mr. McGovern to handle the case. This case was more or less an opportunity for Dr. Morley to discuss the underlying facts and circumstances as to his New York action. There was no contesting the fact that he had the action in New York, and that's the specific thing I believe Dr. Morley was discussing or mentioned, in that he was cooperative admitting that there was actually an action in the state of New York. Otherwise, I believe that the hearing examiner took all of the account from testimony into the record, and I would leave it to the board's discretion. But I would like to thank Mr. Porter for being clear with the record on this case. Thank you very much.
Thank you so much. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Morley?
So moved, Dr. Cockrell.
Dr. Cockrell, thank you. And Dr. Johnson, I think I heard. I will now entertain discussion concerning the matter of Dr. Morley. Is there any discussion? Mr. Giacalone.
Dr. Johnson, I'm actually okay with going for probation and limitation on the practice and getting rid of the suspension. Unfortunately, having dealt with the state of New York, it is a mind-boggling bureaucracy to deal with that. If you've never dealt with them, it's ridiculous. So I am not surprised that this physician ran into that wall. So I don't see why he should be penalized for a technical issue, especially for an agency that doesn't have, quote unquote, their crap together. So that being the case, I am more than happy to give him probation, and the limitation on his practice, he absolutely should have that, you know, given what he's done. There's no argument there because that's a public safety issue. And, you know, I think that's kind of where it lands for me, at least. So that's what I would propose.
Thank you so much, Mr. Giacalone. So we have a motion, it sounds like, to forego the suspension. Is there a second?
I would second that. May I ask a question, Dr. Schottenstein?
Please.
Are you suggesting also, Mr. Giacalone, that we should have a $3,500 fine?
I'm neither here or there on the fine, quite honestly. So I can leave it in or I can take it out, whatever the group decides. I'm more concerned about the suspension, quite honestly.
Okay, thank you. So right now I'm hearing the motion is just to amend and forego the suspension. Is there further discussion?
I do have one question and clarification. This is Benton. The proposed order has conditions for restoration or reinstatement following suspension. So if the board is inclined to remove the suspension, something will have to happen in those terms, either remove them or put them as part of the probation.
See, since you're not getting suspended, what's the value of putting those in, quite honestly? Again, as long as he has the permanent limitation on his practice. Bites, right? Or am I missing something?
It also includes an infection prevention and control course, and the payment of the fine.
Okay.
But the payment of the fine is also addressed above with to be within 30 days. So I think what you could do is put the infection prevention and control course into the probationary requirements if you wanted.
That's fine with me, Kim. So why don't we do that?
Okay, thank you so much. I guess I would just mention that, you know, I appreciate the, you know, the thought that the suspension was just about the delay in producing the records, but, you know, the commissioner's order of the New York board that suspended the doctor's New York license indicated it was based on both the September 8th, 2017 statement of charges as well as the failure to provide records. You know, it may be that, you know, the impetus for it was the lack of ability to, you know, produce the records, but that is what the New York order states. I guess while I have the floor, I'll just speak to the other concern that was raised in the objections, which was the concern about the hearing examiner's, you know, minimum standards reference. You know, so when we have an out-of-state action, the way we determine the fine is to look at underlying violations. The conclusion of law is that the doctor violated the B-22 statute regarding out-of-state action. That's what the board will base its decision on. Is there further discussion? Okay. So if you'd be so kind, then let's maybe have a roll call vote on the amended order. And so
On the amendment.
Forgive me?
I'm sorry, the vote on the amendment.
Exactly. On the amendment. Exactly so. Yes, the amendment. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Mr. Giacalone.
Yes.
Dr. Solon.
Yes.
Dr. Johnson.
Yes.
Dr. Coccarello.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Bechtel.
Abstain.
Myself, Michael Schottenstein, yes. Thank you. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Morley? Motion?
Move.
Mr. Giacalone.
Second.
Dr. Johnson, thank you. Before voting on the motion to approve and confirm as amended, is there any further discussion?
Would you
Okay.
mind just stating what the order is now that it's been amended? We're going to
So-
not, I'm sorry, go ahead.
Yeah, of course. Sorry. So the nature of the amendment, the nature of the amended order is that we're going to forego the suspension. We're going to wrap the requirements for the courses into the probationary period, but the fine is still in place.
Thank you.
Pleasure.
And
Any further
Just to
discussion?
clarify, Dr. Schottenstein, the permanent restriction and limitation is still in place too.
Exactly so. Thank you so much. Any further discussion? Okay, great. Roll call, please, then, on the amended order. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Solon,
Yes.
Dr. Johnson,
Yes.
Dr. Coccarello,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel.
Abstain.
Oh, thank you so much. And myself, Michael Schottenstein, yeah. Thank you all so much. Please turn to the matter of Arthur H. Smith, MD. No objections were filed. Ms. Lee was the hearing examiner. A request to address the board has been filed on behalf of Dr. Smith. 5 minutes will be allowed for that address.
My name is Doug Graff. I'm here on behalf of Dr. Smith, who is also with us. This is based on a plea to a single count of dispensing violation. Dr. Smith was given a 2-year probation, a requirement for some community service, a limitation from working in the area of addiction medicine for 24 months, with the full support of the DEA for the return of his prescribing and dispensing privileges after that time, and a $5,000 fine. What's important to note about this case, even though many things were seen to have been unfortunately billed wrong, no drugs were found to have been diverted. No drugs were found to be improperly provided to patients. No financial gain was found to go to the physicians involved. No improper patient care was cited, but it came down to a billing practice by the clinic that did not change when one of the physicians entered the practice who did not have an X number. Looking at all of that, the U.S. Attorney also found that there was no need for restitution by the physicians involved. Hearing Officer Lee was supportive of returning Dr. Smith to the practice of medicine with a 1-year suspension. He has already been out due to the effect of COVID for 6 months. There's an $18,000 fine, which we think is excessive, and we ask the board to consider these matters. And I turn the balance of my time over to Dr. Smith.
Good morning, everybody. First off, I want to apologize for this whole matter. I never would have imagined I'd be back here before you guys again, never. But please let me say that I really believe that when I was working at this facility, I was really helping the recovery community out. And I was very grateful that Miss Lee found that work was indeed the result of positive outcomes when I had, I'm sorry, I'm a little nervous, when I had been before you guys before several years ago. However, I got to say that I should have been far more mindful and more judicious with which was associated with my name. And I take full accountability and responsibility for my actions. And I've learned a lot from this. But please accept my apologies, everybody. Thank you. Thank you.
Thank you, sir. Does the Assistant Attorney General wish to respond?
Just briefly, thank you, Mr. President. Good morning, members of the board. I would note that this case is from an immediate suspension that the board issued on February 12th of 2020. So since that time, Dr. Smith's medical license has been suspended in the state of Ohio. I think the facts in this case came out that the federal government did not, I guess, pursue a very severe penalty against this doctor. I think that's apparent, and that he just got 2 years of probation. I think that Ms. Lee's report and recommendation carefully reviewed the facts, and I think it drew an appropriate recommendation with the reprimand. I think the fine, $18,000, I'll leave that up to the board. Obviously, that's a pretty hefty fine, but the probationary terms, I think, are important in this case with the office management course. So with that, I don't have anything further to say to the board other than I support the report and recommendation. Thank you.
Thank you so much. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Smith? Motion?
So moved, Dr. Johnson.
Thank you. Second?
Second.
Second.
Mr. Jackalone, thank you so much. I will now entertain discussion concerning the matter of Dr. Smith. Is there any discussion?
Dr. Schottenstein.
Yes.
Whoa.
I'm sorry, Dr. Schottenstein. First of all, I want to just say to Dr. Smith, what an impressive background you have in terms of where you come from and what you went through to become a doctor. And I don't think that we can ignore the fact that obviously you haven't had a lot of it. You worked as janitor and a maintenance mechanic at Air Force, and I think that is to be commended. You worked very hard to become a doctor. Unfortunately, you've made some mistakes that now bring you before the board not once but twice. I think that the reprimand is quite in order, and the probation is quite in order, and would ask the board to maybe consider cutting the fine perhaps in half, if that seems appropriate. But other than that, we don't need to see you again, Dr. Smith. This is unusual to see you twice, and but I did want to at least say to you personally, I'm very impressed with where you came from to be where you are now as a doctor.
Thank you.
Thank you, Ms. Montgomery. So if I'm hearing right, are you making a motion to amend to cut the fine in half, which would be $9,000?
Yes, sir.
Okay. Is there a second?
A second.
Mr. Jackalone, thank you. Further discussion? Dr. Feibel.
I just have a question. You know, this is, I know we have the ability to do this, but if it's prescribed by statute to be this, unless there's some extenuating circumstances, why are we deciding to cut the fine on something like this? Because to me, there's no extenuating circumstances that would allow us, or that would suggest we should cut the fine. So I'm just trying to figure out why we're cutting the fine. If that's the statute, maybe we should change the statute if that's how we all feel.
It's not statutory. The statute allows you to fine, but the fines are based off of the disciplinary and fining guidelines. So the amount of the fine is within the board's discretion. It's not statutory.
I'm sorry, I misspoke, but I thought it was by statute, but the board rules say give a maximum minimum fine, and I realize we have the ability to change that, but I guess if we're going to have those criteria, it should be some unusual situation that we deviate from that, would be my thought, or else we should change the maximum and minimum fine for these different issues.
Dr. Feibel, this is just a personal response for me. I don't think the board is in the business of making money. I think that we're seeing a doctor in front of us, as in many of these doctors, where they are not, they are immediately suspended by act of statute. And so you have this doctor having not been practicing since February, and that's the only rationale. That's the rationale in this instance, is because of an act of statute. Not complaining about the act of statute, this statutory requirement, because of it being drug related, that the immediate suspension caused him to be without employment, and that is the rationale. If this were less benign, if this were more egregious, I wouldn't be commenting on that. But the case that comes before us, even the hearing officer, and frankly, you see the Attorney General's office reflecting the fact that they see the justification of a reprimand being appropriate. So that's the rationale, Dr. Pybel. I'm just looking at his finances.
Thank you. Mr. Giacolone.
I would agree. I mean, look what we're dinging him on, dispensing of a controlled substance. Yeah, he did, but it isn't your typical one that we view in terms of dispensing a controlled substance where it's diverted, et cetera. This is, wrong, yes, but egregious, no. So that's where I guess I would be this.
Dr. Sohn.
Thank you. I appreciate Dr. Feibel's comments on, on reviewing this finding issue, and I just want to weigh in on my opinion. I would argue actually that there are extenuating circumstances in this particular case that would necessitate a lower fine, because when you look at how we did this rubric for this fine, a minimum fine of $18,000 is a lot, but keep in mind that was the minimum fine for a felony drug charge, right? And this is such an issue for us that we decided on February 2020 to immediately suspend this position. But then we come to learn that, we come to learn additional facts. You heard from Mr. Wilcox on his opinion that, look, this guy only got 2 years of probation and stuff like that. And I think those fact patterns we have after the fact may make this an extenuating circumstance to lower the fine in this particular case. So I would support lowering the fine. As for changing the rubric we have, I actually don't support changing the rubric, because we do have the ability to move the needle as we see fit in our discretion. And felony charges, especially drug charges, should be taken seriously. The final thing I want to say is I also appreciated reading the story of Dr. Smith's background, starting out as a janitor. But the other thing I want to mention is I found his apology at the beginning of his speech to be genuine. And I certainly hope he means it. And I would hate to see him at the medical board further.
Thank you so much. Further discussion? Dr. Feibel.
Yeah, real quick. I'm not opposed to lowering the fine in this case. I guess that wasn't my point. But it just seems like we very often will lower the fine from this $18,000 level. It seems like it's a common occurrence. And that's my only rationale for suggesting maybe we change the finding guidelines, because then it gives us the discretion to do this more justly. But again, I'm not opposed to lowering the fine to $9,000.
Thank you, Dr. Feibel. Further discussion? Okay. Let's have a roll call vote on the amendment, please. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Giacolone.
Yes.
Dr. Sohn.
Yes.
Dr. Johnson.
Yes.
Dr. Coccarella.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Bechtel.
Abstain.
Myself, Michael Schottenstein, yes. Thank you. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Smith? Motion?
So moved, Dr. Johnson.
Second, Dr. Cockrell.
Thank you so much. Before voting on the motion to approve and confirm as amended, is there any further discussion? Okay, roll call, please. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Giacolone.
Yes.
Dr. Sohn.
Yes.
Dr. Johnson.
Yes.
Dr. Coccarella.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Bechtel.
Abstain.
Myself, Michael Schottenstein, yes. Thank you. In the following matter, the board issued a notice of opportunity for hearing. No timely requests for hearing were received. The matter was reviewed by a hearing examiner who prepared proposed findings and proposed orders, and it is now before the board for final disposition. This matter is disciplinary in nature, and therefore the secretary and supervising member cannot vote. In this matter, Dr. Rothermel served as secretary, Dr. Safran served as supervising member, and Dr. Bechtel served as secretary and/or supervising member. Please turn to the matter of Rakesh Sharma, MD. Do I hear a motion to find that the allegations as set forth in the November 13th, 2019 notice of summary suspension and opportunity for hearing in the matter of Dr. Sharma have been proven to be true by preponderance of the evidence, and to adopt Ms. Lee's proposed findings and proposed order? Motion, please.
Move.
Mr. Chacalone, thank you.
Second, Dr. Johnson.
Thank you, Dr. Johnson. I will now entertain discussion concerning the matter of Dr. Sharma. Is there any discussion? No discussion? Mr. Chacalone.
Just the comment, I mean, given that this individual's practice of dispensing controlled substance, I think it's appropriate that he be permanently revoked. That's all I have to say.
I agree, thank you. Is there further discussion? Okay, thank you. A roll call vote then, please, to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Sharma. Roll call, please, Dr. Rothermel.
Abstain.
Dr. Safran. Dr. Safran? We'll say Dr. Safran abstained. Mr. Chacalone?
Abstains. I'm sorry.
It's okay. Mr. Chacalone? Dr. Sohn? Dr. Sohn?
Oh, yes. Sorry, I was on mute. Huh.
No worries. Thank you so much. Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Abstain.
And myself, Michael Schottenstein, yes. Thank you. I will now entertain a motion to go into executive session to confer with the medical board's attorneys on matters of pending or imminent court action, and for the purpose of deliberating on proposed consent agreements in the exercise of the medical board's quasi-judicial capacity, and to consider the appointment, employment, dismissal, discipline, promotion, demotion, or compensation of a public employee or official. Motion, please.
So moved, Dr. Johnson.
Dr. Johnson and Dr. Bechtel, thank you so much. Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Chacalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. So the time is 11:01 a.m. We'll wait a minute to start our executive session, please.